To address the legal concerns of the community, Praise AM 1310, 95.1 FM presents Legally Speaking. Are today's hosts.
Good morning, everyone. Thank you for joining us today. We're going to have an exciting show. We're going to have our superstar panelists, Attorney Milton and Attorney Vanita. We also have our special guest, the Marion County prosecutor, who's one of the top prosecutors in America. But there are so many legal issues that have been available this week. But we're going to start with that bombshell down in the Georgia courtroom, Milton, Vanita, with our prosecutor. It was just riveting to watch. And I had a really congested week this week, and I was able to only see about 5 minutes of the testimony. And my first question, starting to Ryan, I don't get this. You have a prosecutor, and I looked up her salary, makes $200,000 a year. You have defense lawyers within 6 months have built over $1 million. And they were complaining because these prosecutors, who she's apparently dating, built over $600,000 in 2.5 years. I don't get this disqualification as to why it merit all this attention, Prosecutor Mears. Why?
It doesn't. It's an old-fashioned political smear job is what this is about. And I think it's important for everybody to recognize, like, there's been a lot of conversation about their relationship. When did their relationship start? That's not the allegation. The allegation that the Trump team is making is that she somehow enriched herself by hiring this guy, and she received benefits from the money that he received. Which is a pretty ludicrous argument. When you look at what he's been paid and the number of hours that he has worked, he is far, in fact, he's worked way more hours than what he's been compensated for because they had caps in terms of how much he could be paid. So then to turn around and say that they are somehow enriching themselves because of this prosecution is ridiculous. Fani Willis gets paid the same amount whether she prosecutes Trump or not. And whatever benefit she might have received from being in a relationship with Mr. Wade is marginal at best. And this is really just a tactic by the defense to try to undermine the credibility of the prosecution, as opposed to, just address this case on its merits. And so for me, this is just an old-fashioned smear job where they're trying to erode the public trust and confidence in this prosecution, because it could very easily be a successful prosecution. And one of the best ways to do that is to challenge the legitimacy of the prosecutor and the relationship the prosecutor has. But there's no legal basis for this. Whether or not she has a relationship with someone is completely immaterial to whether or not Donald Trump committed a crime. And the idea that she's somehow enriched herself or has received benefits because of this prosecution is absolutely ludicrous. The number of consequences that she's faced for taking on this case in terms of death threats and other issues that have accompanied her decision to take on this case far outweigh her getting a free meal from someone who may or may not have been a romantic partner.
I know Attorney Ryan has some concerns about this, Prosecutor Mears.
Much more than Mr. Mears, but I was just jotting down some talking points for myself here. Throughout my life, I've read enough that he who controls the narrative and the spin wins the argument. The truth doesn't matter that much. We've seen it in the Civil War, where many people think still to this day that the South won the Civil War, the Confederacy won the Civil War, especially Trumpers. It's filled with the elements that you want to have a narrative and a spin, and that is money. Doesn't matter what the defense is charging. It matters what the prosecution is spending. Money and sex. What more do you want for the fire? That's the gasoline, that's the food, that's the fuel for any fire. So they got those things. I wrote a note here to Satchel Paige. Oh, Satchel Paige, that's who I wanted to quote. Famous baseball player from the Black Baseball League. He was a pitcher. And they asked him, how did he pitch so long? think he was pitching in his 50s, Nate. And he said, well, when he's looking over there, I throw the ball over here. And when he looks over here, I throw the ball over there. And so anything that you can do to distract the batter, in this way the public, you do it. And that's what they're doing. She just happened to give them some fodder for their fire. That's the bottom line. I understand they came across better than what I first thought. I saw a brief moment of it Thursday because I had to go back to court. And I did not see any of the father's testimony Friday, but I understand from one friend that he did pretty good. So, and we just have to see where it falls, guys. It's in the judge's hand at some point.
And before Attorney Banks responds, our listeners in California, Chicago, LA, and Atlanta, our call-in number is 833-653-3529 because we added Atlanta for this show. But Attorney Banks, I know you had some concern. What does the optic look like to you? I mean, is it put a stain on Prosecutor Willis?
Well, from my perspective, DA Willis has an extremely strong case. But I also agree from your perspective, Milton, that creating distraction is a fundamental component of the former president's playbook, right? Delay and distraction. So what are we talking about this week? We're talking about the relationship between two prosecutors of this case and their personal lives, including their, his relationship with, his former wife and their financial transactions. That's what we're focused on this week, as opposed to what Prosecutor Fani Willis stated. And by the way, she was a commanding presence in the courtroom. And from my perspective, her testimony was credible. And we can talk about Black people and our maintenance of cash in our homes and on our persons. But again, did we really want to be talking about that this week when she absolutely has one of the, if not the strongest case against the former president in Fulton County? I thought her testimony and Mr. Wade's testimony, I thought their testimony was credible. From what I saw was consistent, that from a matter of law, Section 1.7 of Georgia Ethics Professional Responsibility Law, under that statute, there's clearly no conflict of interest. As a matter of fact, two married people on the opposite side of a case wouldn't constitute a conflict of interest. And based on my reading of Georgia law, when we talk about a financial benefit in the case, the only time that there might be a conflict would be if an attorney was paid through a contingency fee, right? And therefore that attorney would have a financial interest in the outcome of the case. But in this situation, as Ryan has stated, there's no conflict. And again, this is just a major distraction. The optics are bad from my perspective. I might lean on the side of taking a position that Mr. Wade might voluntarily step down from the case. And Ryan, I'm interested in your views on that.
Well, I don't think it's necessary, but certainly if that would cure the problem, so we could move forward and actually address the merits of the case, then I don't think that's a bad move at all. Sometimes you have to make pragmatic choices, and if that would alleviate the issue or the concern, then I think that's a good move. Have Mr. Wade step aside and then let the prosecution move forward, and hopefully have their day in court sooner rather than later.
Well, Prosecutor
It's going to
Mears,
be an attraction. It's going to be an attraction. Excuse me, Nate, I'm sorry. It's going to be
Prosecutor, go ahead, Milton. I apologize. Go ahead.
Ryan, the problem I have is now it's going to be an attraction in that trial. When they walk in that courtroom in front of whatever jury it is, someone on that jury is going to know that there's something going on there in their relationship, and they holding hands or they looking at each other, and I smell the sex on them. It's going to come in that court in that trial now. It's there now. The only way to get rid of it is to get rid of it. I'm sorry, but the appearance of that conflict, it doesn't have to be true. It doesn't even really have to be a real conflict. It's just like when you're accused of rape and you get found not guilty. There's that stigma. That's the one who did it. Some of the people still are going to think you did it, even though the victim has recanted. So that's just how it is. You got to deal with that.
Well, Prosecutor Mears, here's what I'm concerned about. The overriding things I've heard in every case involving Trump and that organization, security arrests. I mean, is this type of security risk, is this something unusual for a person in your position? Like locally, do you have concerns? Like apparently these people have death threats every day. It's just bizarre.
Yeah, well, I mean, I think the attention and the intensity of that intention has resulted in people, making death threats and acting in ways that are very aggressive towards the district attorney in Fulton County. And I think that's one of the things that I hope everybody realizes. This is not fun for DA Willis. This is not something that she is enjoying taking on this prosecution. She's doing it because she thinks it's the right thing to do. But not only is she having her personal life picked apart, but she's also receiving numerous death threats from people around the country and in the South because she's taken the position that President Trump broke the law. And so, I hope everybody realizes the enormous strain and pressure that she is under and that she's having to endure. And it goes beyond just internet trolls. These are people who are coming to her house, taking affirmative steps, affirmative acts that certainly make her be concerned for her safety, and those are very legitimate and real concerns. So when anybody who's questioning her motives here, there's not many benefits to taking on Trump. There's a whole huge downside to it, but she's doing it because she believes it's the right thing to do, and I think that's what we want prosecutors to do.
If I may speak up on what Ryan just said, I understood from pretty credible friends of mine, at least two, that she walked in that courtroom Thursday, pretty much took command. She shows that she is a strong woman and a strong leader, and told her team, no, I'm testifying, and contrary to what their position and advice was, and got on the stand and faced the music. And she talked a little too much for me, but I understand at the end of the day, she impressed most people. Now, I'm sure Trump's side is going to say, look at the holes we punched in her and look at how bad they look. But a couple of objective people that I know said that she did testify strong, and she showed that she could lead an office, and she showed that she's a leader. Thank you for that. And then her father came in and he backed her up with how he raised his kids, and she lived like he raised her. And that's why she had money in her possession. So I take all of that, and I'm thankful that they didn't get up there and fall on their face. But still, the next act, the next quarter, the next half, or whatever you want to call it, is coming, and that's the courtroom. And it's going to be a distraction in the courtroom, I feel.
Well,
if they stay together.
Okay, we'll take one caller, then we're going to talk about the bombshell verdict out of New York. Let's take a caller first. A caller, you got a question for us today, sir? Hello, caller? Fred? Okay, you're on mute. Okay, I'll go forward. Yesterday, there was a verdict handed down by Judge Arthur Ergeron out of New York. In the case of People of the State of New York by Letitia James, Attorney General, and against Donald Trump, Eric Trump, Alan Weisselberg, Jeff McConey, the Donald Trump Revocable Trump, the Trump Organization, DJT Holding LLC, DJT Holding Manager Member, Trump Endeavors, 12 LLC, 41 North Wabash Venture, Trump Old Post Office LLC, 40 Wall Street, 7 Springs. So in other words, there was a verdict against Trump and his organization. But the gist of the verdict had to do with common law fraud. And basically, it's a material statement, falsity, knowledge of the falsity, unjustifiable reliance, and damages. In essence, the verdict was so high, I'm still trying to add up the numbers. It was 364 million, but with prejudgment interest, I read today that it's over $450 million. That's an incredible verdict. But one of the things I briefly read was make this verdict so damning was the fact that the Donald Trump and all these organizations can no longer, for at least 3 years, get loans through New York banks. Milton, every bank I know has an office in New York. That's the financial capital of the United States, maybe the world.
True. Well,
now,
I doubt if it's, well, he's going to have to get some hard money from somewhere now, huh?
Okay.
If he's got the collateral to back him up, anybody who would believe he has the collateral, I guess, will loan him money at 50% interest. But I doubt if he could find anyone that believes him now.
Attorney Banks, you got any ideas? How did he get past this unusual set of circumstances?
It's going to be very difficult, and the judge issued a very scathing opinion, 97 pages, where they methodically went through all of these transactions and all of these holdings that you referenced, Attorney Lee. And keep in mind that summary judgment had already been entered on the facts of the case, that he had in fact fraudulently overstated the value of his properties for years and years. And so the decision methodically runs through all of those properties, from the penthouse in New York to Mar-a-Lago to golf courses and others. And the court, ruled against him, as you stated. He's lost one of the biggest cases to date, where he's got to pay over $463 million, and that includes interest. And he's being disgorged, they call it, from some of the benefits of those transactions, including the sale of the post office that was renovated into a hotel. And so he's got to come up with that money within the next 30 days. And so that may, in fact, use up all the cash that he may have on hand. And to your question, he can't do any business for 3 years in the state of New York, and his sons can't do any business for 2 years. And equally as devastating is the fact that an independent monitor will be appointed to actually supervise his business for the next 3 years. So there may be some international oligarchs across the world that might loan him the money, but certainly this ruling is incredibly crippling for Mr. Trump and the Trump organization.
Hey, Prosecutor Mears, got a question for you. This is outside your jurisdiction, I know, but here's my issue. You got a detailed finding of fact that detail what, in my mind, is criminality. How difficult it is for a prosecutor to take on, when you have a detailed analysis that he's done, could that be the basis to commence a criminal prosecution?
Absolutely. I think the one thing that's unique about the fraud provision that he was found liable for, there's not really that requirement that there's intentionality, meaning they didn't have to prove that he intentionally deceived people. They just had to prove that people were deceived. And so that's a big difference in the criminal world, where you always have to prove someone's intent. In this particular civil case, under this law, they don't have that same mens rea requirement, which makes it a little bit easier for the state, in this case, the state of New York, to demonstrate, hey, we have a pattern of deceptive practices of a number of frauds that are perpetrated, and they don't have to prove that they were intentionally trying to defraud people. They just have to prove that a fraud did take place. And so that makes things a lot easier on the civil side. There is a criminal case in New York, but it does not involve any of the things that were $400 million verdict against Trump and the Trump organization. And Attorney Lee, I know you've been a part of these issues. One of the things is, if he's going to appeal, which I'm sure he is, he's got to post some sort of appeal bond. Who's going to, what kind of collateral is he going to have to put up, and how much money is he going to have to put up just to get a appeal bond? The attorney mentioned he's going to owe $400 million in the next 30 days.
May I say this? First of all, good morning, Vanita. I recognize I forgot to say good morning to you when we first started. Apologize for that. Didn't Trump at some point, 25, 30 years ago, get involved with some very rich Russians, and some Russian money was down in Florida, tied up in some property with him? That's number one. And number two, he's got a potential for being president of the United States, a very strong potential. I would think that there are some guys around the world who would be interested in, $1 billion is nothing to some people, man, believe it or not. I would think that there are some people around the world who would be interested in financing Trump in this difficult time. That's the crowd he runs in.
Wow.
And I think that brings up an interesting point. Is that should that be counted as a campaign contribution? Are people posting those bonds because they're looking to curry favor? Are they posted? So should he have to count that as a campaign contribution? How does that work? I mean, I think it raises a number of issues. But he's going to have to come up with an asset or cash or something in the next 30 days as he moves through the appellate process.
Well, also, those supersedes bonds that you post is usually about 20% of the amount of the verdict. But I've never heard any bond posted on a verdict like this before. Usually it's like $1 million or $2 million. I'm not sure that Lloyd's of London or any of those insurance companies want to post a bond that could go up to exceed $500 million. But anyway, let's take a call. Fred, you have a question or comment for us today, Paula? Hello? He went off there again. Okay. Now, the other issue about this is that they had verdicts against his sons also. And I thought that one of the most damning aspects about this verdict had to do with the fact that you have monitors in place. So now, all of his business dealings will be reviewed by a monitor.
Our call is
And
back.
yes. And so my concern is that the things he did before to generate capital, it's going to be overseen by a third independent party. And so what Prosecutor Mears says is really salient. I mean, because we now find out that he used the campaign money to fund litigation expenses. But let me take a call. Fred, you have a question for us, sir? Hello?
Yeah, I'm just hearing the problem.
Okay, I missed him again.
This is a huge blow to Mr. Trump, because keep in mind that his that money, is how he measures his value, right? And so and touting, the success of his businesses. In fact, again, he's not contrite after the verdict. He states that, I quote, built a perfect company, right? And it's going to be interesting how he comes up with $500 million potentially in 30 days. And Attorney Mears raises some really provocative questions regarding how those money should be treated under campaign finance law.
Well, he has another entanglement also. The January 6, 2021 riot, that case raised a series of interesting legal challenges, but it goes very to the nature of what a democracy is all about. That is that no person above the law. And so Judge Chutkan identified him as Citizen Trump. And so now in the criminal case pending in Washington, D.C., the president is claiming an immunity defense. And so if the court takes that serious, I think it could greatly undermine the credibility of the court, because if you say that you can go out and cause harm to people simply because you are the president, it sets a bad precedent. What would prevent, for example, the current president from using, like I say, the SEAL team to go out and assassinate their opponents? I mean, that's the type of stuff that's unheard of in American democracy. I don't know, Prosecutor Mears, maybe you can have some light. This immunity thing, I mean, I've never heard of it before.
Well, you never heard of it before because it's ridiculous and it doesn't exist. I mean, all people in the legal system have immunity. Judges have immunity. A prosecutor has immunity, meaning we don't want people to sue judges because they ruled one way or another on a case. We don't want people to sue prosecutors because maybe they take on an unpopular case. But this idea that somehow that immunity extends to every single thing that we do in life is ridiculous. And it's not what the immunity was intended to do. What immunity is intended to do was allow people, if they're in the legislature, if they're a governor, if they're a mayor, or even the president, is to be able to carry out their duties without fear of litigation. But this idea that everything that you do is somehow protected by that immunity provision is absolutely ridiculous. And what President Trump is trying to do is argue that as long as he's president, anything that he's doing is directly related to his function as president. And that's not what the law says. That's not what the law was ever intended to do. And it's a very dangerous argument that's being advanced. I think it's really noteworthy that in the district court level, at the Court of Appeals level, everybody has been dismissive, and it has been unanimous that this is a ridiculous argument. But we have a Supreme Court that is incredibly ideologically driven right now, which makes some people concerned that maybe they'll give some merit to this argument, should they take it up. But so far, everybody who's addressed it has said what we all know to be true, that no, when you're president, the law still applies to you, and you have very limited immunity when you are doing your very official duties that are prescribed under both the United States Constitution and sometimes in statute. But if you're acting outside of that, you have no immunity. And that's the way it should be. And turning that on its head is pretty ridiculous.
Well, he seemed to have been successful in finding some legal scholars to support his position, though, hasn't he? So,
well, he's not calling you or I'll tell you that much.
Well, Attorney Grime, you spent $55 million on legal fees. And so let's not forget about that. That's a hell of a lot of money to spend on lawyers.
And that'll keep him alive for a few more days, if not years. So that's the power of the rich.
The DC Circuit Court of Appeals in their 57-page opinion got it right in unanimously ruling that the former president is not immune from prosecution for criminal acts committed while he was in office. And as you stated, Attorney Lee, they referred to him as now Citizen Trump. And
but the Supreme Court hasn't spoken on that, have they, Vanita?
The case has been appealed to the Supreme Court. They have not spoken, but they should reject this appeal on the grounds articulated by the DC Circuit Court of Appeals. We'll see.
Yeah,
you seem skeptical of that, Attorney Grimes.
Yes, I am. I am very skeptical of that. I mean, this is a court looks like a political apparatus now, and you know, would you say it's going to be a unanimous decision that he's not entitled to immunity?
Well, because of the composition of the Supreme Court, I'm not sure. No, not at all.
Thank you.
In answer to your question, not at all.
Right.
And it's truly unfortunate because the DC Circuit Court of Appeals, I mean, it's an outstanding opinion, and I would recommend everybody to read it.
You know, every now and then we've had some significant surprise verdict in American history. I remember one of the seminal cases had to do with Brown versus Board of Education. That decision shocked America. It came out unanimous. At that time, you know, everybody thought that the Supreme Court would be sharply divided. Somehow the Chief Justice was able to pull the different justices together and make a unanimous decision. So in the interest of American democracy, hopefully the Chief Justice Roberts is able to marshal all the justice, even the ones that the meetings have been bought and paid for, you know, that you'll be able to get some uniformity of a decision here because it dealt with the core value of American democracy. That if you were, presidents are not king, presidents are not dictators. So nobody could say with any rational basis that the president could encourage the assassination of the vice president. I mean, this whole case was so ridiculous in my mind. You know, you have people who attempt to overthrow the federal government and also murder the vice president. I think that that part of it should have been a wake-up call that they're cheering on, you know, hang the vice president. So the fact that you had citizens go that far to try to overthrow the federal government, I think it's something that the Supreme Court should not take lightly. But the thing that bothers me is that all of these cases about one person, they're all gravitating towards the Supreme Court. And normally the Supreme Court took very limited amount of cases. But one person seemed like every week we're talking about Supreme Court and Trump. It doesn't, make a lot of sense to me in the sense that the fact that they're giving them these venues, I think it's ludicrous. Now, one of the things that's going to be fascinating about this process is this, is that the fact that you have the Supreme Court dealing with this, and there's an esoteric Florida law. Remember that the Florida governor went to great lengths to try to keep felons from voting and restoring their rights. Or Florida has law that felons can't run for office, they can't hold office. If Donald Trump is convicted, what will be the legal consequence of that? Because now we have these states that said that he should be kicked off the ballot, but Florida has a law, and it's going to be really fascinating to see exactly how that plays out.
Well, I personally look forward to watching them all torture reason and logic to justify not only voting for a felon, but keeping a felon on the ballot, given their prior positions on a number of these issues. They've certainly set up a circumstance in which you would think he would be disqualified in many places. But as Attorney Grimes said, he certainly seems to have some friends in high places as it relates to legal help and not just the kind that you can hire.
Yeah. Well, but in terms of a legal analysis, the ballot challenges that were being raised and the 92-year-old Republican litigator from Colorado who started the Colorado case. I was reading her story, really a fascinating story. But these cases all now gravitate towards the Supreme Court. And the legal scholars' consensus is that you can't allow any state to elect the president. It's the United States. So therefore, it looked like these ballot challenges in these states should go away. But I'm really curious, though, if he's convicted, how does that affect these states that enacted laws to prevent inmates, particularly a large amount of minority inmates, from being able to vote and hold office? It's going to be a really big challenge because the court's going to have to do legal jujitsu to get out of this, in my mind. Now, the other issue that I needed some close to, we had this verdict, Prosecutor Mears, were in Michigan, in the state of Michigan, the mother was held liable for the murder of her son at that high school. And these type laws, they're prevalent in the country? Is that an isolated incident like in Michigan? Do we have something like that in Indiana?
We don't have something like that in Indiana. So she was charged with involuntary manslaughter, and involuntary manslaughter in Indiana is you committed a misdemeanor, and as a result of that misdemeanor, somebody died. And so I don't know what the underlying misdemeanor would necessarily be in Indiana. As everybody knows, in Indiana, we have really no gun laws. One of the few is you can't sell a gun to a minor. So maybe potentially there, you would have an ability to try to file something. But it's definitely a unique prosecutorial decision. But it's not something that I think a lot of places have, because I think in most places, Indiana kind of follows the traditional common law definition of involuntary manslaughter, which is you commit a misdemeanor and someone loses their life. That's really, so you'd have to find an underlying crime that you could say the mom committed, and then from there, you could potentially try to pursue involuntary manslaughter. I give the folks in Michigan a lot of credit for coming up with that idea and that strategy to hold parents accountable, because I know we hear from people in the community.
Well, Prosecutor Mears, I've successfully litigated cases against parents and gun owners who allow teenagers to have access to gun and cause harm to other folks, because it imposes civil liability, and a lot of people don't realize that it's covered by their homeowners insurance policies. And most people homeowners insurance policies a minimum of 300,000 up to a couple million in terms of liability. So the civil liability has been relevant for the distance entirety of my practice. We've been able to impose that because my thought process is that if you own a gun, it carries some additional responsibility. That is that, you know, you must store it in a safe compartment, and it must not be accessible to teenagers who could cause harm. Because one of the problems that I see now is that there is a great amount of teenagers who are engaged in violent conduct. And so the only way, and then we had this issue like in the Super Bowl. I've not seen the results of that yet, but I thought that it was teenagers involved with the shooting at the Super Bowl party of the Kansas City.
It was.
Oh, it was teenagers?
Yep.
So when the teenagers engage in outrageous conduct like that, can they be charged as adults?
Indeed, they could be. You know, once you're over the age of 16, the most violent offenses, the prosecutor has no choice. They have to be charged as adults. If you're less than 16, then you have to have a hearing in front of a judge if it's in the best interest of the child versus the best interest of the community. But if they're over 16, most violent offenses, the prosecutor has no choice to pursue in the juvenile court. It has to be pursued in adult court in the state of Indiana, and many other states are kind of following that trend due to kind of high-profile incidents like this.
Milton, you're on mute. No.
I said in California, there's a slight difference in that the district attorney has a choice of having a fitness hearing where both sides present evidence, probation department present evidence in favor of the prosecution position that this young person is no longer for the juvenile system and can't be treated or rehabilitated within the juvenile system, and they should be tried within an adult system because the crime was one of sophistication, et cetera, et cetera. So there is a choice in California whether you be tried as an adult once you're 16, but you are not qualified for, you do not qualify for adult court if you are not 16 or older. That's the difference.
Well, I need some clarification. Do juveniles that are less than 16, do they get jury trials or those trials by court?
No, it's a court trial. It's a court trial. At least in California, you don't have a jury trial until you become an adult. Then you have a right to a jury trial.
So same in Indiana. It's a bench trial for juveniles.
Okay, I see. And so what happens to juveniles now that uses the guns that are purchased by their parents? Will there ever become legislation, you think, in most states that adopt something what Michigan did?
So in Indiana, we're advocating for it right now as safe storage law, where if you don't store your guns safely and they're used in a crime, that you could be charged criminally. I'm not optimistic it's going to pass, but that's one of the things that is put forward every year is a comprehensive safe storage law that says exactly what you just pointed out, Nate, that if you have a gun, you have an obligation to store it in a way that, you know, prevents kids from having access to it. And if you don't, you can be held criminally liable.
We have a safe storage law here in Illinois, and in the aftermath of the mass shooting in Highland Park, Illinois, a year ago, July 4th, the parent father was criminally charged, and he accepted a plea deal in that case where he was jailed for a very short period of time. I'm thinking maybe 30 to 60 days, and paid a fine in that case. And so from my understanding, the Michigan case is the first case that went to verdict on this issue of parental accountability for the acts of a student or their child's mass shooting.
Okay, let's go back to the line again. Hey, Fred, you have a question or comment for us, sir?
Yeah, can you hear me now?
Yes.
Great. I can't believe it. Technology, not my favorite thing. This is actually for Prosecutor Mears. We knew in Indianapolis now, Attorney Grimes and Attorney Anita, we now have a new police chief. And I'm just curious as to the new police chief's policies. Does he work with the prosecutor's office closely? Because obviously, I think he has some ideas about how he's going to eliminate some of the gun crime in this community that we live in. And certainly it may make your job a little easier. It could be making it a little bit more difficult. So Prosecutor Mears, how are you going to handle that?
Well, we do have a new chief police here in Indianapolis. It's Chris Bailey, someone who is really no stranger to the police department. He's had various positions in overseeing different parts of IMPD, and he's been the number 2 for the last 3 or 4 years. So we do have a close working relationship with him. He's someone that I talk to very frequently. And certainly I think he's going to dedicate additional resources to try to do something about guns. He, like the rest of us, our hands are kind of tied just because Indiana doesn't have a ton of gun laws. So it's difficult for law enforcement to be proactive in that regard. But he's certainly willing to dedicate the resources to make that happen. Kendall Adams is still chief of investigations. I know Kendall is making sure that they're following up and doing everything that they can to make sure that they're in a position to present great cases to the prosecutor's office so we can move forward and hopefully hold people accountable. So the relationship is there. It's just working under laws that have very much changed and are in favor of everybody walking around carrying a gun.
Well, I'm certainly glad that you're in the position you're in. Makes me feel a little bit more confident about what could possibly happen in this city, particularly since we've had a change in leadership at the top of the police department. Great show. Thanks.
Thank you.
Pierre Pullins, you have a question or comment for us, sir? Pierre?
Oh, good afternoon. Can you hear me, Nate?
Loud and clear.
Oh, good afternoon, all. I want to apologize real quickly to Fonnie Willis. I know she's listening to the show. I had her all wrong. After her testimony, it was powerful. And after I heard the facts and her explain what went on, this is a big nothing burger. And I'm glad to see that the judge was pushing the attorneys along and dealing with some of their nonsense. One of the things that Fonnie said that impressed me, that she has a unit that prosecutes police and election fraud. And she didn't stutter. She didn't say voter fraud or anything like that. She said election fraud. So I am impressed with those prosecutors down there in Georgia. Real quickly, I didn't hear any, you talked about Trump running for office. Well, felons can run for federal office. I don't know about insurrectionists. I don't think they can. But felons from Maine to California to Hawaii, they can run for federal office. And Trump has to go down because, people are losing faith in the justice system. If he gets off, that's going to be a big blow to people's faith in the justice system. But the one last question I wanted to ask you and Mr. Mears to address, it's a local issue. Our Supreme Court is considering whether this guy running for Senate, I think his name is Rust, is going to stay on the ballot. And we got another local race here. Shania Graves is challenging Gene Breaux for her seat. Will the Supreme Court or the Election Commission allow them to stay on the ballot? I want to thank you for taking my call this morning.
Yeah, I mean, I think the Russ decision, and for those of you who don't know, just to provide a little bit of background, we had a Republican United States Senate candidate who the election board basically didn't certify to be on the ballot, and he appealed. He won at the trial court level, and then at the Indiana Supreme Court level, they said no, actually he can't be on the ballot. And I always get concerned when we're not allowing people to run. I think it's one of the most important things is people should have access to democracy, and part of access is making sure candidates have the ability to run. There's a number of barriers that are set up, in particular for federal candidates in the state of Indiana, in terms of their qualification on the ballot, and that's exactly what happened here. I don't think anybody should be afraid of a little competition. And if there's someone who wants to run for United States Senate, whether they're Democrat or Republican, I don't think we should set up these arbitrary obstacles. The obstacle in this case was, his voting history. And I just think that's something the Indiana Supreme Court should stay out of. And we need to let people have access to the ballot. I don't know how you feel about it, Attorney Lee.
Well, as we speak now, I talked to Robin Winston, who used to be state director. There was a challenge filed this week against Joe Biden running for president in Indiana, and also one against Donald Trump. The one against Biden was filed claiming that he did not have enough signatures to be on the ballot. And I talked to their campaign people. They had probably twice the amount of signatures necessary, so I'm not sure what that entails. But the second one, filed against Trump, is based on the Section 3 of the 14th Amendment. And the challenge against him is similar to one filing in Colorado. So I suspect that these challenges going to be filed in every state now, because that's the way we're going with this litigation. It appears that because Trump is being challenged, Biden's also going to be challenged. Go ahead. I'm sorry, Mr. Pullen. What were you saying, sir?
So has the Supreme Court hasn't decided the Russ decision case yet, have they?
Yeah, they did this week.
Yeah. Prosecutor Mears
they took it up.
Hey, what happened in the Russ case, Prosecutor Mears?
What's that?
Did they issue it?
What happened on the Russ case, you say? What happened on that case?
Yeah, they issued an opinion, I think, on Thursday, where they said that they overruled the district court's ruling that said he could be on the ballot.
So they're saying that he can't be on the ballot?
He cannot.
Oh, so he didn't have enough signatures?
No, it was a different issue related to whether or not, I guess, he was a Republican, voting in primaries, something along those lines.
Oh, so he was running as a Republican, and he ran as a Democrat before?
Something along those lines. I can't remember exactly what it was, but the Supreme Court said that they overruled the district court's ruling.
Oh, I see.
You have to have voted in the last two primaries for if you're going to be on the ballot for that party. So if you're going to be a Republican, you have to vote in the last two Republican primaries. If you're a Democrat, the same thing. That's on the filing sheet. That's on the candidate form.
Yeah, and Russ, for what it's worth, Russ said he's going to appeal to the United States Supreme Court. So we'll see if they take it up.
He's got the money. All right.
Any closing comments from Attorney Grimes and Banks? We got 1 minute left. Attorney Banks?
I was on mute. I'm sorry. Please go out and vote. I think that's what we got in front of us. We have got to become a more participatory society in our elections.
Attorney Banks?
I agree with that wholeheartedly. I believe and have stated many times that the most important obligations of a citizen is one, to vote, and two, if you're called, to serve on a jury.
Attorney Ryan, Prosecutor Ryan?
I couldn't agree more with Attorney Grimes and Attorney Banks. People have to participate in the process, and if people don't vote, if they don't participate in the process, it hurts our democracy. And there are people who are out there who are trying to destroy our democracy right now. And the best way to combat that is to go out and vote.
Well, thank you, everyone, for joining us today, and we'll be talking to you next Saturday. Until then, may God bless and keep you. Goodbye, everybody. Talk to you next week.